Hello, I'm Bill Peterson, Minnesota probate attorney. One of the questions that comes up from time to time in our probate practice is what will happen if the personal representative dies before the estate is closed? Now, it often comes as a shock when a loved one dies, but things can get even harder for the family when the person who's been named as the personal representative dies before the administration of the estate is complete. The personal representative, also known as the executor, is responsible for many of the activities in the Minnesota probate process, including collecting the assets, organizing the estate, distributing assets, and communicating with the probate court. While the family and friends are dealing with the loss of a loved one, this person is managing the decedent's estate. But what can happen if the personal representative, himself or herself, also dies? The death of the personal representative happens more than many people realize. I've had this happen several times in recent years in some of the probate cases that I've handled with my own clients. While each time has been a somewhat different situation, there are established ways of taking care of the matter. Under Minnesota law, the original probate process must still be completed according to the probate code. This means that a substitute personal representative must now be selected to take the place of the one who passed away. Now, there are several ways to go about the selection of a new personal representative, but it must be done with the approval of the probate court. First of all, it's helpful to review the will, if there is one. Often, the deceased person will name alternative choices to serve as executor or personal representative in case the first choice is unable to serve. As a side note, naming alternatives is a sound practice in estate planning. If there is no will, or if it does not nominate a new personal representative, then it's a good idea to ask the heirs or the beneficiaries who they would like to see as the new personal representative. Now, they may not all agree, but this can avoid needless and, frankly, expensive conflicts in probate. A discussion among the beneficiaries tends to be a good idea so that everyone involved is aware of the change that needs to be made. Of course, it's a good idea to nominate an individual who is knowledgeable in financial matters and who is acquainted with the family and the financial affairs of the deceased person. It's also important to be sure that any candidate to become personal representative does not have any skeletons in their closet, such as personal financial problems or criminal convictions or personality conflicts with the other heirs. If no executor has yet been appointed by the probate court, the petition to the court and the supporting documents can be redrafted to nominate the new candidate. If the probate proceeding has already begun, then it will be necessary to file a petition to name a successor personal representative. If the probate court had required that the deceased executor or personal representative post a bond in the probate, it may be necessary to get that bond discharged and get a new one for the successor personal representative. When a personal representative has died, in addition to the loved one, this can create an enormous emotional crisis for the family. At this time, more than ever, it is important that an experienced probate lawyer is there to sensitively guide the family through this doubly difficult time. I'm Bill Peterson, Minnesota probate attorney. If you're dealing with this kind of situation, I can help you. Give me a call toll-free at 1-888-910-5297 for a no-cost, no-obligation consultation. Thanks, and have a great day.